Spousal support, also known as alimony, can be ordered only if the two parties were married to each other. Under the new laws, effective January 1, 2005, in some cases, partner support is also available, which is similar to spousal support, except that it does not have the same tax effect. This means that if you were never married to your child's other parent, or you never registered your partnership, you cannot get spousal or partner support. If you are eligible to get spousal support and you have children with the other person, you might also be able to get family support. I'll talk about family support after I've finished telling you about spousal support. There are other differences between spousal support and child support. There is a guideline amount for child support, and the guideline is available for temporary spousal support, but not permanent spousal support. Spousal support can be negotiated between the two parties, and if they agree on the amount. The court will uphold that agreement. In child support, if one party changes his or her mind after coming to an agreement, the court will order guideline support. Another important thing you need to know about spousal support that is different from child support is that the person who pays it gets to deduct it from his or her income when figuring out income tax. And the person who receives spousal support must include it in his or her taxes, the same as if it were earned on a job. This means that the payer gets a tax break and pays fewer taxes, and the payee pays more taxes. Because the domestic partner laws are state laws, not federal laws, the IRS does not recognize partner support the same as spousal support. That means that the partner support is not deductible for the payer, and the receiving parent does not pay taxes on it. But there may be other tax effects, so you should consult a tax person if you fall into this category. There is temporary spousal support and permanent spousal support. I'll talk about temporary spousal support first. Temporary spousal support is available to married persons after the petition for dissolution, legal separation, or nullity is filed, but before all the issues have been finalized in your judgment. Temporary spousal support is computed the same way as child support on the DissoMaster, support tax, or other computer program, or it is negotiated between the two parties, usually based on one party's need and the other party's ability to pay. Go back and review the segment on child support to understand what goes into this computation. Temporary spousal support and temporary child support are orders that are usually made at the same time to try to hold things together until you have either negotiated a settlement or you've gone to trial. Permanent spousal support cannot be figured out on the computer by the judge. There is a case that says doing that is an abuse of discretion. So instead, the judge has to look at a whole bunch of factors. These factors are spelled out in Family Code Section 4320. They include the following: each party's earning capacity, the marketable skills of the supported party, including possible education and training to develop those skills, the extent to which the supported party's present or future earning capacity is impaired by staying home to take care of the family instead of being in the workforce and developing marketable skills, the extent to which the supported party contributed to the other party's growth in earning capacity through education, training, career positions, or licenses, the ability of the supporting party to pay spousal support, taking into consideration that party's earning capacity, earned and unearned income, assets, and standard of living, the needs of each party based on the marital standard of living, the obligations and assets, including separate assets, of each party, the length of the marriage, the ability of the supported party to go to work without unduly interfering with the best interests of dependent children in his or her custody, the age and health of both parties, documented evidence of any history of domestic violence and its effects on both parties, the immediate and specific tax consequences of the support, the balance of hardships to each party. There is a public policy goal that the supported party will become self-supporting in a reasonable period of time, which is generally 1/2 the length of the marriage. The criminal conviction of an abusive spouse shall also be considered in making a reduction or elimination of spousal support. See Section 4325. Anything else the court determines is just and equitable. Sometimes it takes a long trial to get all the evidence about all the factors in front of the judge, but when people cannot agree between themselves, they are stuck going to trial to get a permanent spousal support order. Family support is a combination of both child support and spousal support, without being able to say how much is for one and how much is for the other. This is often ordered by the court when one parent makes a lot more money than the other parent. The reason is because family support is tax deductible to the payer, just the same as spousal support, and the receiving parent has to pay taxes on it just the same as if it was income from a job. In some cases, because of the tax effect, it will mean that even though the payer is paying more money than guideline child and temporary spousal support, that parent pays a whole lot less in taxes and ends up having more money available for his or her needs after taxes. And the receiving parent has more money for her or his needs after taxes. It's a way of keeping taxes money away from the government and putting it in your pocket. It does not always work this way in every family situation, and the only way to find out if it will work in your situation is to run the numbers through the computer, Dissomaster, Support Tax, or other program. If you're not sure this is for you, then you should get a consultation with an attorney. Or at the very least, go talk to the family law facilitator in your county.